to Legally Speaking. With me, Tarun Nangia. We are discussing today a landmark judgment that was authored by Justice Dhananjay Chandrachud, the Chief Justice of India, which is the case name is State Bank of India versus Rajesh Agarwal. This is on the RBI's fraud circular. And this judgment gives the promoter and the company an opportunity of hearing before they're declared as a fraud account. Now, this is very, very, very important because this has brought relief to thousands of businessmen across the country who would have been, in a sense, unfairly labeled as fraud accounts or had the possibility of being labeled as fraud accounts and putting them out of business in some cases. But to discuss this issue, I have with me my guests today who are an expert in these kind of cases. I have with me Neha Nagpal and Malak Bhatt from NN Law Chambers. They specialize in these kind of cases in the past couple of years. And nomenclature of what you called as fraud circular lawyers was lightly said about them in the courts of law because they ended up doing so many of such cases. I would like to welcome Advocate Neha Nagpal and Advocate Malak Bhatt from NM Law Chambers. So nice to have you on the show today and looking forward to some interesting insights on this judgment. May I request Neha, could you give me an opening comment on Justice Dhananjay Chandrachud's judgment?
Thank you, Tarun. It's always a pleasure to be on your show. And this indeed is a very interesting development that's happened, especially not just for the economy of this country, but also for the business landscape and for what we call as white-collar crime landscape. The frauds, reading in the requirement of principles of natural justice, i.e. a hearing before declaration of fraud, has come as a big relief to the business community. It is once again the Supreme Court of India and the Honorable Chief Justice in particular has sort of reiterated and strongly reiterated, in fact, the valued principles of liberty and the right to do business in this country. So really, I feel what this judgment does is it makes the promoter of this account, which is being considered as a fraud account yet to be declared at some stage, gives them an opportunity to be a part of the process. Till day before is when the judgment was pronounced, but till day before, we were in a situation where if an account got declared a fraud, nobody knew. There were various consortium banks and different dates declaring an account as a fraud. And the only way maybe promoters got to know is when CBI landed up at their doorstep saying, oh, now there's an FIR against you, or if some of them were traveling, there was an LOC against them, or in some parallel proceedings if there were reference to this. So at least today there's a state of semblance. You can participate in the hearing. You can transactions which look dodgy, you can explain them, and then you can take whatever course of action you have to take once you know the reasons for which you have been declared a fraud account. So it definitely is a very welcome step.
Okay, it's a welcome step in a sense, the interest of ease of doing business in India also. I'll go across to Advocate Malak Bhatt. Malak, your opening comment on this really important judgment delivered by Justice Chandrachud.
Thanks, Arun. So I will in fact break this up in three parts. It definitely is a welcome step, but as one would expect Justice Chandrachud's judgments to be, it fortifies the requirement of reading fundamental rights into situations where vital stakes and interests are involved. So if you look at the judgment, it has three very, very important characteristics. Number one, it is well balanced. And that one has to remember because the prayer made before the high courts against which the SLPs came up was that the fraud circular should be quashed for the want of a right of hearing not being there. So while the judgment does deal with the fact that yes, a right to hearing has to be there, it also recognizes the importance of the circular to the extent it says that it's one of the steps that the banking industry uses for the purpose of preempting fraud that perpetrates in the system, in the banking system, and therefore it upholds the circular. It does not quash the entire circular. It only reads in the right, number one. Number two, it is a very critical requirement that today Justice Chandrachud has read in the requirement of accountability within the banking system for the purpose of promoters at the stage of which when they get declared, the account gets declared fraud. And that is the core principle of administrative law that the judgment reads into that very system. What the judgment effectively says is that, look, it is not a mere reporting mechanism that the bank is trying to do. Any action of the bank which has an impact on the rights and interests of the promoters or of the account will definitely have to meet the bare minimum standards of administrative law, as we call it today, which is that you have to at least be show caused as to what is the case being put against you. You will have a right to be heard on, or a right to be to give an explanation to the allegation being put up against you, and the order which is being passed against you will be a reasoned order. These are the three very basic principles of administrative law, which in India has been developed from E.P. Royappa to A.K. Kraipa. Today, I would see this judgment to be nothing but an extension of that very core principles of administrative law. And probably 5 years from now, this judgment will be read in that line of judgments to be one of the core critical decisions which read down important rights for the business industry within the banking regulations that exist today.
Point well taken. I'll go across to Neha Nagpal. Now we'll begin deconstructing the judgment. First, we'll try to understand what was the fraud circular all about, and then we move on to what the arguments were made in court. Neha, could you explain the viewer what was the fraud circular about? What did it contain? Why it was, in a sense, a worry for the promoters?
So see, the master circular on fraud was introduced, at a time when the rise of NPAs in the country was, there was a serious rise, and this government was making all steps possible to try and curtail the banking system, the public banking system at least, from unprecedented failure, which was important at that time, Tarun, because there was a series of steps that were taken. The Insolvency Act, so the Insolvency Code, the prior there to the S4A, so on and so forth. And this was a part of that, because you can't just clean up a system without, also coming understanding what was the wrong. And so the fraud circular came about with a very good intention. One, it talks about an early warning signal. Annexure 2 of that circular, recognizes a series of criteria where there is an early warning signal. Suppose it's prior to when you become an NPA. Maybe you're simply at an SMA1. And then that sort of required whether it was, a single lender or a consortium of banks to then red flag the account, which was called a RFA account. And then at that stage, get an external help through a forensic auditor to conduct a forensic audit of that account. The most critical parts of that circular were, one, to say that fraud will have the definition under the IPC. Secondly, it said that there will be penal consequences that will also follow under clause 12.8 of that circular. But the real heart was clause 8.4, 8.4.5, 8.4 and 8.4.5 of that circular, which basically said that if there is a single bank, the single bank can go ahead and declare the account as fraud. If there is a consortium, then the one member of the consortium has to inform all the other banks to say that, look, there is an early warning signal. I'm marking it as an RFA. Let's get a forensic conducted. And once the forensic exercise is done, then together 60% of the consortium members had to approve declaring the account as fraud. Also, there was a particular timeline that was given. This entire process had to be completed in 6 months, because obviously you can't have restrictions, or you can't keep an account in sort of, in an early, because obviously even when it's an early warning signal or a RFA, there are limits that came into play in terms of usability of that account. And then there was, of course, while we talk about the penal consequences, there were also consequences that, that account cannot, it has to, the banks concerned or the consortium concerned had to inform the banking system. They had to be properly notified to RBI as well. And then there were limits on not just creditworthiness was impacted, but also for the credit availability of credit, the promoters of that company were prohibited under Section 29A of the Insolvency Code from becoming resolution applicants. So there was a series of fallouts, which is what is also now in this judgment been called civil consequences, or what we call civil death of not just the company, but also the right of liberty of the promoter. So what really the biggest problem with this circular was that very well you identify the account as EVS, you identify the account as RFA, you get a forensic started. It's only at the stage of forensic can the forensic auditor reach out to the company and the promoter and say, oh, we're conducting a forensic, please come and answer our queries. But there was no obligation to share the report with the promoter or the company. There was no obligation to invite the comments of the company or the promoter before the final forensic report was submitted by the auditor to the banks. Then there was no requirement to conduct a hearing before the banks went and declared a fraud. Now, there may be a related party transaction, which is seen as siphoning of funds, but that may not be the case. That may be genuinely a bona fide transaction, or it may have been a loan in advance, which is actually paid back or adjusted somewhere else. Who can explain that but the company or the promoter or the management behind it? And like I mentioned earlier, so this declaration of fraud then happens on the basis of this forensic report, which is not with the promoter or the company, which is never put to them. Their comments are never invited. The banks unilaterally go declare fraud, and for these promoters then to struggle with these consequences, which can meet them for a very long period of time and literally finish a thriving business and mar a reputable promoter's image for times to come. So it was in this context that various petitions were filed across the country challenging this circular at a very threshold level, that hear me before you seal my fate.
Point very well taken. I'll take this now to Malak Bhatt about what were the arguments made in court against this master circular on fraud, details of which just Neha shared with the viewers.
So let's get to the background of how this matter reached the Supreme Court. This was actually two separate appeals that came up. There was a judgment from the Telangana High Court which confirmed the view taken by the promoters that yes, one has to be heard before a declaration of fraud is castigated by the bank. So the Telangana High Court actually read in the requirement of natural justice within the fraud circular. On the other hand, you had a Gujarat High Court judgment which had taken or endorsed the RBI's view that this is ultimately only a reporting mechanism. And because the declaration of fraud is nothing but a consequence of certain actions that the bank has seen within the play that's happening in the account. And it's nothing but a factual finding that the bank really comes to basis what the forensic auditor finds. This is not really an action which is taken by the bank which has any judicial consequences. It's not an exercise in judicial in law to be considered to be a decision of the bank. And therefore, it need not have an element of hearing. And that's the view that the Gujarat High Court had taken. So both the matters came up together, were tagged before the Supreme Court. Now, the primary two contentions that the promoters had raised, and large part of this was also touched upon by Neha, is that, look, today, the manner in which the RBI circular is framed, there is a requirement for the bank to mandatorily declare me a fraud if the categories of the definition of fraud are met. So the forensic auditor does come to a finding that yes, A, B, C, D, E, F have happened, which are within the ambit of the definition of fraud within the RBI circular. Then the bank will necessarily declare me a fraud. Now, the declaration of fraud per se, if one looks at it in isolation, will have no meaning. But if you look at clause 8.1 to 8.12 of the circular, there are various consequences that take place. The biggest of that being that you cannot avail any further banking facilities, number one. Number two, consequences of being a willful defaulter will automatically flow. And number three, you will be debarred from accessing the capital market, as well as you will also be debarred from being a director or promoter of a company going forward, where other stakeholders are also involved. So ultimately, it's a financial death for that promoter, that company, that business orientation going forward. So the argument put forth by the promoter was that, look, if ultimately the consequence is going towards a situation where my rights And here we are talking about an essential fundamental right, not just a legal right, a right under Article 19(1)(g) is getting violated. The least I expect law to do is to give me a hearing before that. The second argument was that part of this entire exercise is that you have a forensic auditor who comes into play. So I am expected to be at least given a show cause of the findings that are put up against me by the forensic auditor. I should be provided the necessary documents which form the basis for that. And the order that you give on declaring me a fraud should obviously contain the reason as to why my explanations have not been accepted. Now, the counter argument of the RBI and the banks was that look, you have to read in administrative law principles of natural justice, etc., within the context in which the circular was framed. So if you look at the purport, the objective of why the circular came into being, it was to preempt, detect, and prevent to the extent possible any fraudulent exercise within the banking regulation system. So if I as the bank am required to give notice to the borrower that look, I am in the process of declaring you as a fraud account, then it will wither away the very immediacy with which this is to happen. Number two, it will scuttle any further investigation or any further action which is to be taken against that promoter or that company, because the promoter will get a hint of what is going to happen. And the biggest example that the banks give over here was that one of the actions which follows after declaration of fraud is that I am mandated to file a criminal complaint before the investigating agency if it's beyond a certain threshold to the CBI, if it's under the threshold to the state police or the EOW. So the moment I give show cause of the fact that I am in the process of taking steps under the RBI circular, the promoter will get whiff of the fact that things are proceeding towards that end, which will ultimately scuttle a criminal investigation where the ultimate finding of guilt is to happen. And the last argument raised by the bank was that, look, if you look at the manner in which this entire exercise is framed, it is an economic policy decision of the RBI to declare accounts as fraud. So since it's an economic policy, as the law of the land stands, courts should be circumspect of entering into that fray and should leave that to the experts. So there is no requirement of a hearing to take place because ultimately it's only nothing but a reporting mechanism, not even reaching the threshold of an administrative decision. Now let's break this down, how the court comes to the finding. I would say very poignantly put, civil consequences has been defined within the judgment, not very clearly, but if you read the manner in which Justice Chandrachud has dealt with it, any action which has an impact on the way in which you will deal with your business undertakings falls within the ambit of Section 19(1)(g), Article 19(1)(g), your right to do trade and profession, which can only be curtailed with reasonable restrictions. So any action which today has the consequence of not just a mere restriction on your right to do trade, but goes to the extent of curtailing you from accessing the banking facilities going forward, curtails your entire manner in which you will do business, is actually much higher. So he says the civil consequences here are way higher than what you would expect a mechanical reporting mechanism to do. And therefore, he reads in the requirement of natural justice, number one. Number two, he says you cannot buy, and this is a very interesting concept that he has brought about. Till now, the arguments that we've always seen play out in court is that if a natural justice principle is not specifically recognized in a statute or in a regulation, it means it's impliedly excluded. He has reversed this principle to now say you cannot impliedly exclude principle of natural justice unless you specifically said that you will not be given a hearing. So by way of implied inclusion, he now says while the circular does not, touch upon it, it also does not say you will never be given a hearing. And since fundamental rights, part 3 of the Constitution, is way higher than a mere RBI master direction, this principle necessarily has to be read into it. So that's aspect number one. Aspect number two, which is I find to be the more critical part of this, is he says while this entire process can take place, you will give a show cause, you will give detailed documents, etc. The order given by the banks has to be a reasoned order. And this is drawing on from the fact that we've seen SBI versus Jar Developers, which was on the lines of, which was a judgment on the willful defaulter side, where Justice Nariman clarified that, look, a bank, when it declares someone as a willful defaulter, has to give a reasoned order. That jurisprudence today has developed through the Delhi High Court, Bombay High Court, and various High Court orders to say the principles of natural justice have to be inbuilt to the extent that the bank, while declaring willful default, should also give a reasoned order to say why you are declaring them a reasoned order. And now with the fraud circular also being brought into that ambit, what happens is that you cannot wish away my explanation to say, look, I have looked at your explanation to ABC. I find the forensic report to be more sacrosanct than your reply. Therefore, I'm not accepting your reply. I'm declaring you a fraud. This today cannot stand, which in fact, in cases we have seen happen. There have been cases where a bank, for the formality's sake, has given a show cause, has given me a hearing, but ultimately given a one-line decision saying I'm accepting the forensic audit report. So that today is the more critical part of it, where the bank is now held accountable to give a detailed reasoned order. And the last part of this, I'll just touch upon this in 30 seconds, is that he says in the judgment that apart from civil consequences and the right to be heard, one interesting aspect is that you cannot just be heard by the forensic auditor and be told that, look, that's past substantial compliance, because it's the decision maker, which is the bank, which has to give you a hearing. And that again, we've seen practically happen where forensic auditors are seeking clarification from the promoters, and the promoters are told by the bank that, look, you've already been heard by the forensic auditor, we need not hear you anymore. And that he categorically denies to say this is not acceptable.
Okay.
I think just one point there, which Malak has beautifully articulated, I'd just add one small point, is that the banks have also tried to say that this is a time-bound process and therefore we, excluding the right to hearing. But Justice Chandrachud has even pointed out on that 6 months is enough time for you to complete the whole process and give a hearing. So he's really, I think, very strongly upheld the right to do business, the right to liberty, and the right to reputation through this judgment.
Okay, point very well taken. We'll go to the next point that now, Malak, you explained what arguments were made and then relief was indeed given by Justice Chandrachud. I want to know, what about the people who have already suffered and declared fraud, Neha?
So, that is really right now, it's I'm going to say that it is definitely a vexed question that comes before all of us. It's not that there is no solution, but it's just that solution now, in light of this ambit that has been laid down by the Honorable Supreme Court, is going to still be very fact-based on every particular case. I can give you a situation. There may be a case where, because of a fraud declaration, a company is taken into insolvency. The insolvency is in an advanced stage. Subject to applicability of Section 12A of the Code and Regulation 30, now, because the fraud declaration will go, because there is no opportunity of hearing was given, the 7th June 2019 circular, which allows banks to consider a one-time settlement by a promoter, and except for where a promoter is declared as a willful defaulter or a fraud, can today be, maybe if circumstances permit, such a promoter can make an offer for a one-time settlement. Secondly, there will be consequences on LOCs that were issued by banks pursuant to declaration of fraud. Those will also fall. Most importantly, the declaration of fraud as is against the company and the consequent impact on the promoters will go. But then again, one will have to see whether the complaint is only made to CBI or the police. Has an FIR been registered? Has a charge sheet been filed? Those will then be specific instances. Now, cases where there's only a complaint, one can still try and, maybe write to the bank to try and say, look, now that this fraud declaration has gone and the wheels of time have been sort of set back, this should also be held back. If it is just at an FIR stage, appropriate recourse can be considered there. Now, if it's a charge sheet stage, it's a whole different ballgame altogether. But I do think that despite all of that, most individuals, most promoters, most companies should definitely seek for that declaration of fraud, which was without giving them a hearing, to go and definitely go back to the banks and say, now hear us before you do anything else. Because that will definitely aid with all these other proceedings in some, at the appropriate stage. That is really the way I would think of it right now. And like I said, it's going to be all very individual case based as well.
Okay, point well taken. I'll go to Malak Bhatt for his opinion on the same.
Yeah, so I mean, if the way forward is at the courts and at the strategy level both. A lot of petitions are already pending before various courts where they were waiting for the Supreme Court judgment to come in. So everyone whose declaration of fraud today is pending adjudication before these various high courts will obviously all be quashed and set aside, which automatically the way forward for these promoters companies is that they revive themselves back into the banking system, and they're then left to avail whatever remedies they have under the various RBI circulars, including the fact that they'll be now open to availing more banking facilities to ensure that whatever shortfall is there or whatever efficiencies are there in terms of their outstanding debts can be resolved sans the criminal proceedings. Let's look at how criminal proceedings will span out. One very interesting aspect that the judgment talks about is that it says that while this entire process on the civil remedies side, which the bank takes, will require a right to be heard, there is no requirement for the bank to hear you before going and filing a complaint or before registration of FIR, because that's the normal criminal law to set in motion. That if you have cognizable information in your hand, that should be sufficient for you to go and file a police complaint, and the police is mandated to register an FIR. So if the declaration of fraud, which is the fulcrum of the case, goes, will the criminal proceeding also automatically lapse? Will have to be seen on two fronts. One will have to be seen as to whether the declaration of fraud is the sole basis for the bank to have actually gone and filed the complaint. If that is so, then I assume one will be able to take up an argument, what we generally call as the fruits of poisonous tree, and say that, look, if the very root of this entire criminal complaint has gone, and you are filing a criminal complaint only basis this, only, and I stress on the word only, then the criminal complaint or the consequential FIR should also go. However, and that again is a part of our practical experience, what we've seen is that banks, apart from declaring the account as fraud, has also taken large part of cue from its existing internal reporting mechanism, the excerpts of the forensic audit report, some categorical finding of the forensic audit report, which may not typically be within the four ambits of the fraud or the definition of fraud, but has used that to say, look, some criminal offense has definitely been committed, so we are registering the FIR. Will that FIR stand is again something which will have to be tested in court. And the last part of this obviously is if the criminal investigation has proceeded to an extent, because a lot of promoters would have faced the brunt of this, and for them the judgment comes in too late, because a declaration of fraud would have happened, say, in 2018-19. Today, the criminal investigation has reached a point where things are already proceeding at the court level, where police, after investigation, has actually found that there is an offense made out and a charge sheet has been filed or charges have been framed. To them, I feel this judgment is more of a remedy on the civil side than on the criminal side, because it does not to that extent help them unless that case specific facts can be maneuvered around to show that, look, ultimately this is the sole decision why all this has happened. And that argument today, I believe, will be tested in various other high courts.
Okay, thanks so much for sharing all this perspective on the judgment by Justice Chandrachud on the RBI's master circular on fraud. This was indeed enlightening in the sense that people got to know what are the implications of the judgment and what is the course of future. We also discussed what about people who've already been declared fraud? How could they be helped? Thank you so much, Malak Bhatt and Neha Nagpal from NM Law Chambers for sharing all these details with the viewers. Looking forward to discuss this issue some more, because I think there will be an implication of this judgment which will have to be discussed in the months to come. So maybe in a month's time, we'll request for your time again. Thank you so very much for joining. Thank you.
Thanks,
so much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.